Hello, and thank you for coming to this presentation here at the Hopkinton Senior Center. For those of you who don't know me, my name is Arthur Bergeron. I'm an elder law attorney. I'm at Myrick O'Connell. There are 70 of us at Myrick O'Connell, 40 in Worcester, about 20 in Westboro, where I spend most of my time, and about 10 in Boston. We're actually the biggest firm outside of Boston now. Because there are so many of us, everybody gets to specialize in what they really like doing, and I do nothing but elder law because I really like it. If you have not been here before, you may not know my friends Frank and Mary and their kids Peter, Paul, and Mary Jr. Their goal in life is very simple. They want to live in their house until they die. They want to be buried in the backyard. Ideally, they want to leave everything, if one dies, to the other, and then if the two of them have died, to their kids. And so in this presentation, though, we're assuming that it's just Mary, because Frank, whether he is gone there or whether he's gone there, is no longer around. So the real question now is for Mary to figure out how her estate plan is going to be working. She also wants to be dealing with her kids, Peter, Paul, and Mary Jr. They've got various family situations of their own. Maybe some of them have kids. Maybe Peter, Paul, and Mary Jr., maybe some are doing great, maybe some aren't. So she's got to try to figure all of that stuff out. So if Mary at this point is, we'll say younger, 65, 70 years old, then she's got slightly different concerns than if she were older. So we're going to start off by talking about her a little bit younger, and then talk about what the concerns are that change as she gets older. So if she's still younger, then her issues are making sure that if there's a problem with a short-term disability, she needs to go to the hospital for a while, whatever, that there's someone there to take care of her things. She needs to make sure that her estate plan basically works. Ideally, she wants to structure her estate plan so that if she does literally drop dead, that her family can avoid going through the probate process. And she wants to make sure that she's not going to waste any money on estate taxes. If Mary is 65, we're going to assume Mary is 65 for the time being, and then there are her assets. She's got a house worth $350,000. She's got savings of $250, an IRA worth about $300, an annuity worth about $200. Her total assets are $1.2 million, and she's got total income monthly of $2,000 a month, all from Social Security. Using those assumptions, we're going to be using those numbers later on when we talk about some of these other alternatives. So the two things she has to have first are a healthcare proxy, and the reason for that is very simple. She needs to know that if she does go into the hospital for something, but that something happens, that there'll be somebody there that can handle her health care needs for her. The health care proxy is really simple. You need to have two witnesses. The only issue is that the witness can't be one of the people you're naming on your proxy. It's only effective when your doctor says in writing that you can't make a medical decision, and you can only have one agent at a time. You can't name a couple of your kids jointly on your health care proxy, because if I'm the doctor and you're not well and I need to know what to do, I don't want to have two of your kids arguing with me. So you can only name one person at a time. Raise your hand if you have a healthcare proxy. Just about everybody. Raise your hand if you know where it is. Could you find it quickly? Most of you, right? So that's really important, kind of knowing where it is. Where should it be? Certainly your agent should have a copy of it, just in case. It should also be with your doctor. Your doctor is required under the healthcare proxy law, if you give the proxy to him, to make a copy and keep it in the record. That way, no matter where you are, no matter what hospital you're at, if somebody can reach your primary care physician, they can get that healthcare proxy to the person. The hospital is kind of a place to have them, but you can't be guaranteed at the hospital that they've got them. If you went to the hospital and you got admitted, and as a condition of admission, they said, oh, you have to sign this healthcare proxy, which they want 100% of the people there to have signed them, because if something happens in the hospital, they want to know who to call. When you left, they probably threw that healthcare proxy away. So you really want to make sure that you have your own proxy, and especially that your doctor has it, okay? Power of attorney. I'm going to start off by telling a power of attorney story. So I have a client right now who is in Framingham Union Hospital. What is it called? Metro West Health Center at Framingham Union, right? Who I think is going to die. He had a kind of a serious stroke, and he's in the hospital. He may die, or if he makes it out of this, he's going to end up in a nursing home. He's got, say, $100,000 in cash, or in cash, in the bank, at Bank of America. And he never thought this would happen, so he never had a power of attorney. So his sister called me and said, so what can we do? So we went to see him at the hospital. I realized at that time he couldn't actually sign his name. He could tell me that it was okay for someone to sign his name. So I had his sister sign the power of attorney. I notarized it. They went to Bank of America. The next day, they wouldn't take it. They said, oh no, you know, if it's not his signature, we need a special form with extra witnesses that certify that this person authorized somebody else to sign the form for him. So I said, okay. So we redrafted the power of attorney. We went back a couple days later with the new power of attorney, and we had 2 extra witnesses, and we had one of his brothers there, and we had him authorize his brother to sign the power of attorney on his behalf, authorizing his sister to act as his agent, and I notarized it. And then the next day they went back to the Bank of America. And the Bank of America, and I wasn't there, they went. I got a call later from the lady, distraught. Bank of America, they said, wouldn't take this power of attorney. They were very concerned about it, and that therefore I needed to call their legal department. So I said, what number do I call? And my person said, well, they gave me the number of the customer service. I said, are you sure they're going to talk to me at customer service? Oh yeah, that's what they said. So I called the woman at Bank of America in Marlborough and said, so this is what I'm told to do. Is that, am I sure I can just call customer service? Yep. I called customer service. Well, of course, I get a computerized lady who didn't talk to me, who just said, before we can talk to you, we need the social security number or an account number, which of course I didn't have. So I called back my person and said, can I have the social security and the account number? Yep, okay. So then I go back and call, now I'm on the line again, and I punch in the social security number, and now I get a human being in California who says, who am I talking to? And I said, I'm Arthur Bergeron, and I'm the attorney for the person, and we're trying, he says, oh, do we have a power of attorney for you on file? I said, well, no. I said, I'm only calling because your person at the branch in Marlborough, Massachusetts said this is what I was supposed to do. And he said, oh, we can't talk to you. You don't have a power of attorney. And furthermore, he said, we never connect people directly with the legal department. You can't call it, because I said, let me talk to the legal department. Oh, you can't. And I said, but wait a minute. I said, this is exactly what I was told to do. And I said, you're just telling me now that there's no way to deal with this. So he said, oh, let me put you on hold. 15 minutes later, he came back. Said, there's nothing we can do for you. There's nothing we can do for you. Have your woman go back to the Bank of America and talk to. I said, but she did that. That's why I'm calling. So here we are. We're now stuck. We're stuck. We can't get any of his funds. If he were dying, I would be recommending that he reshuffle his funds to get them out of his name so he doesn't have to go through probate. If he's living, then we need to reshuffle his funds in order to have him qualify for mass health. In either case, we can't do anything because there's no power of attorney. So, I mean, 2 notes to file. 1, I would never go to Bank of America if I had one of these issues. But 2, you got to have this power of attorney. You have to have the power of attorney, because you don't know. I mean, at any time, something like this could happen to you. But at our age, there's a real likelihood that it could happen to you. You have to have this. So, power of attorney. You don't need any witnesses for it, right? Except in this unusual case, when you're authorizing somebody else to sign your name for you. But unless you have property out of state, because some states do require witnesses on a power of attorney. So if you want to deal with property in New Hampshire, property in Florida, you need those witnesses. Notarization is preferred but not required. There's no legal requirement in Massachusetts that a power of attorney be notarized. But I have found in my 42 years of practice of law that there is something magic about having a notary seal on a document. Because because lay people just look at it and go, oh, that means it's a legal document. It makes no difference, but it appears to make it more legal, and therefore that's why you should have it. So that if you're going to the bank or whatever, it's going to appear to people like this lady that I had to deal with, we're having to deal with at Bank of America, that it looks more official. You can have joint and alternate, or joint and you can name more than one person at a time on your power of attorney. You can name 2 of your kids at the same time. For example, jointly and severally, the legal consequence of that is either one of them can act for you if the other one isn't around. You can, and doing a new one does not automatically revoke an old one. So if you don't like the person you've named on your power of attorney, then you can do a new one, naming somebody else. However, doing the new one does not automatically revoke the old one. So you also need to notify the person whom you had originally named, saying, I'm revoking your power of attorney. I don't want you to do it anymore. Also, as a tip, if that situation occurs, also go to the bank or any other financial institution that has your assets and let them know you did that. The reason for that is there's a provision in your power of attorney, I bet, that says that if your agent named in your power of attorney goes to the bank and signs an affidavit at the bank saying that as far as he is concerned, or she, the power of attorney has not been revoked, and the person who named that person has not died, the bank will give him all the money. And the bank does not liable for giving him all the money in that case. Because and that section is designed to make sure that if you've given somebody a power of attorney, they can go to the bank and get your funds, right? Because otherwise, they could just get stuck if somebody at the bank questioned and said, well, how do I know the power of attorney is still in effect? But as a result of that, if you are revoking, if you don't want somebody, you need to notify folks who have your assets if you're revoking your power of attorney. Power of attorney provisions that you need to look at. If you've got real estate and you want your attorney to act on your behalf, then there has to be a section in there saying the attorney can do that. If you want gifts to be makeable by the person whom you're naming as the agent, you want to deal with that. Let me talk to you about a lady I met in Lancaster yesterday, and her problem is that she got assets. She and her husband actually, there are some things in his name, and his power of attorney, which he gave her a long time ago, names her as the attorney and names the kids as alternates, and gives her the ability as the attorney to make gifts, but not to herself. She can only make gifts to the kids. And those gifts are limited to the amount of what's called the federal gift tax exemption, which is now $15,000. We're going to talk about that exemption later on. But the point is, she's got a real problem now, because we're going to try to qualify her husband for mass health, which means we have to shift all the assets out of his name and into her name, and then have her do some other stuff. But we can't do that. We can't do that because the power of attorney doesn't allow us to give money, her to give money to herself. We can give money to the kids, right? That's what the power of attorney says, but not more than $15,000 per kid. We've got to move a lot of money, right? And if we give the money to the kids, then that actually violates the mass health regulations, because that gift would be subject to the 5-year look-back period. So we've got a real problem. So that, once again, the bottom line on this is, you want to have somebody look at this, look at your power of attorney, if it's an old one, to make sure that the right sections are there to make sure they can deal with your issues. Next, getting the estate right. If I marry, I do want to make sure that when I die, my assets go to my kids. At least I think that's what I want. So you want to, first of all, if you want that to happen, and those are your natural children, and you die without a will, that's where your assets are going to go. Your assets are going to get divided equally among your kids. So you don't need a will in order to have that happen. The issue, though, is that exactly what you want to have happen? So does any of your children have, these are kind of the big three, a creditor problem, a marriage problem, a disability problem. Does your child have creditor issues so that by leaving things to them, you're really leaving it to the creditors? Do they have a marriage problem so that you're leaving something to them and all of a sudden that asset is part of the divorce, right? Do they have a disability? so that they may be on Mass Health or on Section 8 or on SIS, programs that are means tested, so that giving them assets may disqualify them for that program. In that case, then you do want a will, and you want to say in your will probably that the assets that would have gone to that child will instead go in trust for the benefit of that child. And you probably name one of your other kids as the trustee. Finally, about grandchildren. I know a lot of people will say in Mary's situation, well, I want to leave some of my assets some of these things right to my grandchildren to take care of their college. And that's fine, except you should understand that if you're doing that, what you may be doing, instead of really giving the money to your grandchildren, is you're giving your money to Harvard or to wherever this child is going to school, because when they go to school, before their financial aid package gets figured out, they have to file a form, usually based on the FAFSA, F-A-F-S-A, the federal form that is the standard form that is used by the federal government. And the school's evaluating that, while they're not required to evaluate these assets in a particular way, will usually subtract those assets dollar for dollar from the assets from the financial aid package. Because as far as the school is concerned, the grandchild has the money, and that's what it's there for, is to pay for school. So they're going to subtract that from the aid package. So you just want to be aware of that, okay? Every family is different. We've talked about those three kind of basic issues that the kids may have to face. There are a few other things that if you're doing a will, that you want to make sure you take care of. Don't build in any ties into the will. Don't name two of your kids, as the personal representatives, the people who they used to be called the executor or the executrix. Because what if they disagree? Or if they do disagree, make sure there's a tiebreaker that's built into the will. That's often a role that I have been put into in wills. I've probably been named a tiebreaker hundreds of times. Never been asked to break a tie. Because as I tell people, I told a lady yesterday, you know, every time they find out they have to pay the tiebreaker, they figure it out. So if you have an even number, put in a tiebreaker. Finally, regarding your house, if there's something special about your house that you want to deal with, like you want to give one child a special ability to buy the house because they've taken care of you or for whatever reason, or you want to give all of them the ability to buy the house, make sure that you're clear on the numbers, especially on the price. Don't say in the document, oh, it's just subject to the house being appraised. Typically what I would say, use a fixed figure like the assessed value, the town or city's assessed value at the time of your death. So there's no argument, because you don't want this to be causing arguments, okay? And finally, well, we talked about the grandchildren a little bit. Probate avoidance. Once you've dealt with what you want your plan to be, your question is whether you can structure your plan so as to avoid the probate process. Why do you want to do that? Well, what is the point of probate? The point of probate is to do two things. One, to make sure that the correct people get your property. If you die owning a piece of property individually, if you own it jointly with someone else, then when you die, the person you owned it jointly with automatically gets it. If there are assets like IRAs or 401ks or typically annuities that name death beneficiaries, when you die, that person's going to get it, right? But the issue is, how do you deal with the rest of the assets? Commonly, that means the house, also the car. Especially the car is the most common reason why there is an inadvertent probate, because you die, there's a title to the car. The only way you can change the title is by going through the probate process. So if you've got a car, kind of your only way around dealing with that is to actually name somebody jointly with you on the car, one of your kids, so that upon your death, the child becomes the instant owner of the car, right? Now, it may be that your child doesn't want you to do that because they think you're a terrible driver, right? And they're going to get sued. So in that case, you may have to increase your insurance. But I'm just saying the car can be a real issue, and the house. And so the question, so that's one purpose of probate, is to make sure the right people get the assets. Now, in this case, as I mentioned to you, with or without a will, the same people are going to get the assets. And the fact that you have a will doesn't avoid probate. It simply explains at the end of the probate process where the assets go. Because the other reason for the probate process is to pay creditors. And that's the reason why probate takes a long time. Because creditors of yours have 1 year from the day of your death to file a claim against the probate estate. And if they do, then they're entitled to be paid before anything else gets divided up. So if you want to avoid that, then you have to make sure that there are no assets that end up needing to go through the probate process. And the best way to do that, and remember, wills don't avoid probate. And the other reason for avoiding probate is people will every once in a while say, well, I can do this myself. Maybe you can, but there are a ton of forms. This is a legal process that you need to be dealing with the probate court on. Most people end up starting to do those forms and they just give up. So if you have to go through probate, you're kind of wasting several $1,000s in attorney's fees just by having to go through this process. And most importantly, it just takes your kids a lot of time. And remember, of course, as I say this, at this point, you're dead. So you're only avoiding the probate process for the benefit of your kids, so that they can avoid some hassles and so that they can avoid some costs. So if that's not a big concern, don't worry about it. But so here are Mary's assets. She's got a house. She's got savings worth $250. She's got an IRA or a 401k worth $3. She's got an annuity she's named a beneficiary on. If she dies tomorrow, is probate required? Raise your hand if you think it is. Raise your hand if you think it isn't. It is, because she has to deal with that house. She just owns it in her own name. So now somebody has to figure out who gets the house. Same thing with the bank account. There are some banks where they will allow you to name a death beneficiary on the account, typically by putting it into something called a taught and trust account, where you're named on the account as the trustee, and the person you want to get the asset is named as the beneficiary. But as far as the bank is concerned, you have total control of that account until you die. When you die, the beneficiary, if they bring in a death certificate, the bank will give them the money, right? So it's effectively a kind of trust. So the ways to, speaking of which, the ways to avoid probate if you're single are, first of all, most importantly, look asset by asset. Because the goal is to make sure that none of the assets individually is going to force you into the probate process. If you've managed to avoid it with all the big assets, but you're still stuck with that car, you may still have to go through probate. It'll be a cheaper form of probate, but it's still going to be a hassle, right? So look asset by asset. One way is to make sure that every asset is owned by you jointly with somebody else. And I gave you the example of the car. Some folks will also do that on the house. My suggestion on the house, if you know that you want to stay in your house until you die and you want the kids after you die to become the owners of the house, one thing you can do is you can transfer now an interest in the house to the kids. It's called a remainder interest, and keep a life estate. The life estate is total control of the house until the moment of your death. The remainder interest is the rest. It's so the kids at the moment of your death become the total owners of the house. One advantage of doing that is that you're avoiding probate. Another advantage is that 5 years after you do that, that interest that you gave your kids is no longer countable for mass health purposes. We're going to talk about that a little bit later on. So there's also, for bank accounts and things like your annuities, TODs or PODs, transfer on death or pay on death provisions. So check with your bank or with your other financial entity like Fidelity or whatever to see if you can simply name a death beneficiary. I'm going to talk about trust in a second. Finally, though, remember, there is always last-minute giving, as I was hoping to do with my friend who is stuck in the hospital right now at what was Framingham Union. You can, in this kind of situation, suppose you've named someone as your attorney, on your power of attorney, and given that person on your behalf the ability to gift things. But you don't want to gift things now because you might need them. But suppose you just tell your attorney who has the power of attorney, look, here's how I want things to be distributed. In the case of my friend that I was talking to you about, his no wife or no spouse, no kids, wants things evenly divided among his brothers and sisters. So you give one of the brothers and sisters the power of attorney and you say, before I die, take my remaining assets, specifically the bank accounts, and just give them away. Just give them away then, according to the way that I would have wanted to give them away. And then you can just avoid probate. Now, I know there are these issues about gift taxes, but I don't know if I have a slide on this. No. So the issue with gift taxes, there is no gift tax. There is no gift tax. Well, there is no gift tax that will affect you. Let me just talk about these for a few minutes. There is no Massachusetts gift tax. And by the way, remember, the receipt of a gift is not income. So if you're giving things away the day before you die to your brothers and sisters or to your kids or whatever, the receipt of this money by them is not income. It's not reportable in their income tax. They're just getting it. There is no Massachusetts gift tax. There is a federal gift tax. Actually, I talk about this a little later in the slides, but I'll go through it now. There is a federal combined gift and estate tax system. And the way the system works is, if you die right now and you have an estate of worth more than $11.4 million, you will pay an estate tax on that extra amount, the amount that's over that number. Now, in order to make sure that you don't give that money away at the last minute, as I'm suggesting here, the federal government says there is also a gift tax. And so if you give away more than a particular amount, then that money that you've given away basically gets added back into your estate at death for purposes of determining whether you owe an estate tax. But there are two exclusions to that gift tax. One is the one you all know about. And it is that you can give away no more than a particular amount in any year to one person. And that used to be $10,000. And over the years, that number has gone up, and it's now $15,000. You all know about that one. Everybody knows I can't give away more than $15,000. There's another one, though. If you go over those exclusions, you have an additional lifetime exclusion equal to the amount of the estate tax exclusion, $11.4 million. So if you give somebody $115,000 this year, then the first 15 is excluded because it's the annual exclusion. The other 100 is excluded because it's part of your lifetime $11.4 million annual exclusion. What you're supposed to do if you make that gift is you're supposed to file a gift tax return so that you can tell the government you gave away the extra $100,000 so they can subtract it from the $11.4 million, because after you've done that gift, now you can only leave at the time of your death $11.3 million. So you're supposed to file that gift tax return. And many people will say, well, you've got to file the gift tax return. Well, ask somebody if they tell you that. Well, what if I don't? What if I don't? The answer is that you pay a penalty. But the penalty is equal to a percentage of the amount of the tax that you would have paid if you owed a gift tax. But you don't owe a gift tax because unless you've already given away $11.4 million. So there's no reason to file. So this whole the whole gift tax thing is just a joke. So there is always this possibility that you could just give things away. So another possibility, this is commonly used by folks who own a home, and you want to keep control of your home while you're alive, but you want to avoid probate. And therefore, you don't want to convey an interest in your home to somebody else while you're alive. In that case, what you do is you create a revocable and amendable trust. You name yourself as the trustee of that trust. A trustee is the person who is in legal control of assets for the benefit of other people called beneficiaries. So a revocable and amendable trust, you name yourself as the trustee, you name one of your kids, Peter, Paul, or Mary Jr., as the successor trustee. You say in the trust, you have total control of the assets while you're alive. When you die, though, the successor is going to step into your shoes, take all the assets, and do whatever you say they're supposed to do in the trust. The trust stays revocable until the moment of your death, at which point you can't revoke it because you can't take the property back because you're dead, right? That's what revocable means. A revocable trust is a trust where you can take property back out of the trust if you want to take it out, right? So if in Mary's case, if she did that and then conveyed her house to herself as the trustee, and if necessary, made herself the trustee of that bank account, then during her lifetime, she retains complete control of these assets. There is no bad tax consequence to any of that. As far as the government is concerned, she still owns the assets. This is a so-called grantor taxable trust. So all tax implications go to her. If she sells the house, she still gets her $250,000 exemption. It's exactly the same as she owned it. But if she dies, the new trustee steps in immediately, can take the assets and divide them up. Why would you want to do that? As I mentioned, there are no tax implications. You can name more than one trustee if you want, although typically Mary will name herself as trustee and then name the successor. There are instant distributions after death. And also, finally, you're avoiding creditor issues. Because as I mentioned, the point of the probate process is to make sure that the creditors get paid. So I'll give you an example. I have a couple, a wonderful couple, used to live around Boston. Guy had a good job, worked hard, has a good sized pension, was a job with a lot of pension but not a lot of savings. Had 7 kids, raised all the kids. Most of them went to college, and they co-signed on a lot of loans. And some became doctors and lawyers, and they paid those loans, but others became artists and other things, and they had a lot more trouble. And so there's still debt outstanding, a couple $100,000 in student loans, because you know, those things add up, right? The interest rate adds up. And they've been paying these small payments to these companies, the student loan companies, but they're very concerned that when they die, there's going to be this big debt. And the reason why they're concerned is they got a house. They got a house that they bought in Nantucket in the early 90s for a couple of $100,000. And it's Nantucket, so now it's worth $1.6 million. Not a big, huge house, it just is in Nantucket. And they said, well, what can we do? And I said, well, very simply, you just put your house in a revocable and amendable trust and name one of your kids as the successor trustee after you die. And when you die, your house will not go through probate, which means the creditor claims will simply evaporate, because the claims are only against the probate estate. So if you've got that kind of issue, there may be a reason to do a revocable amendable trust. Estate tax minimization. Estate tax issues have become more relevant because of real estate. Because if you own a house and you have some, IRA or 401k savings, and the house is in Hopkinton, the house is worth several $100,000, which means you're more likely to hit these numbers, right? So I'm just going to go back through the numbers. Remember, in this case, Mary's house is worth $350,000. She's got savings, she's got an IRA, she's got an annuity. It's $1.1 million is her total assets. All of that is taxable. All of that, whether it's goes through probate or not, is part of the taxable estate when she dies. Any asset that you have control over, even a life insurance policy that has no surrender value. If you own the life insurance policy, and the life insurance, which means you can name the beneficiary, when you die, the proceeds from that life insurance policy are part of your taxable estate, right? So in this case, she's got a taxable estate of $1.2 million. And she'd rather that her kids not have to pay the estate tax. The question is kind of what can she do? So to understand that, you first need to understand a little bit about the estate tax. So there are 2 ways of calculating the Massachusetts estate tax. There's kind of the old way, and then there's an alternate. The old way was adopted in the 1920s when Massachusetts created the estate tax, because they wanted to make sure that people dying with a lot of wealth, that there was a tax that got paid before the kids got the money, so that they wouldn't just derive the bonus just because they happened to be the children of rich people. And at that time, in the 1920s, the definition of rich was $40,000. $40,000. I was amazed at that figure until I remembered that when my folks bought their house in Marlborough, their 2-family house on French Hill in Marlborough in 1940, they paid $2,000. And of course, they needed a mortgage for that house, and they needed the rent from the other unit so they could pay the mortgage, right? So 40 is 200 times 2. No, 20 times 2, excuse me. 20 times 2. So that exemption now is much higher. We're going to talk about that in a second. But the point is, that chart is still in effect. For the money between $40,000 and $90,000, you pay an estate tax of 0.8%. Then for the chunk of money between 90 and 140, it's 1.6%. And the numbers keep going up. It's a graduated system. And using that tax chart, if you had $1 million you would owe a tax of $36,560. Wow. If you had $1.1 million, which is Mary's estate, you'd owe an estate tax of $42,640. And that chart is still in effect. But wait, you say, you've never heard of this chart. Isn't there something about $1 million, right? Well, what happened over time is that property values went up. And it turned out that everybody was having to pay an estate tax if they had a house, because they kept on going over these numbers. And in response to that, people leaned on the legislature, and the legislature did something. Now, they could have amended this chart, but they didn't. Instead, what they did was they said, okay, you know that $40,000 amount below which you don't have to pay? We're going to change that number, and we're going to make it $100,000. And then later they made it $500,000 and $6 million. And then eventually, about 20 years ago, made it $1 million. So if you have an estate of $1 million or less, you don't pay any estate tax. But then the question is, what happens if you're $1 over? What if you have an estate of $1,001? What happens? Well, in some states, not in Massachusetts, but in some states, and I know that this was true in Rhode Island until a few years ago, their estate tax was referred to as a cliff tax. There was a magic line, like this one. There was an old chart, which is still in effect. There was a line, and if you went over the line, so if you had it, and I think the line, when they finally changed their estate tax system, was $650,000. So if you had an estate of $650,000 or less, you paid 0 estate tax. If you had $1 over, you fell off the cliff, and you owed all of the money you would have owed under their chart. Well, in Massachusetts, they did it a little bit differently. They said, okay, and this system was adopted a long time ago, it's still in effect. It says if you have an estate of over $1 million, you calculate your estate tax 2 different ways, and you pay whichever one is lower. Whichever one is lower. The first way is take the number on the chart. So if you're at $1 million, you pay 36,000 something. If you're at $1.1 million, you pay $42,000. Then look at the alternative. If you're $1 million or less, you pay 0. If you're over $1 million, you pay 40% of all the dollars over $1 million. So in this case, if you're Mary, and Mary dies and it's Mary's estate, using the chart, you owe $40,000. Or excuse me, using the alternative, you owe $40,000. 40% of all the dollars, 40% of that extra $100,000 over the million. Using the chart, you owe $42,640. So in this case, you use the number that's in the chart. If Mary's estate were $1,001, she'd owe 40 cents, right? Under the chart, she'd owe a lot, but 40% of all the dollars over $1 million, which is $1, is 40 cents, right? So as you can see from seeing these numbers, these lines cross. The alternate tax number and the chart number cross fairly soon, right? Because even at $1.1 million, the chart paying 40 cents on the dollars over $1 million has almost, or excuse me, the alternative has almost caught up to the chart, which is only 42,000. And the lines actually cross at about $1,120,000. At that point, after that, 40% of the dollars over $1 million is always more than the chart. And as a result of that, at that point, effectively your rate drops for the remaining dollars to the chart, which at that point is about 6.4%, right? It's much, much lower. Yeah, 6.4%. So that's how the estate tax system works. So if you're Mary, then you've got this concern because you've got an estate that's $1.1 million, which means, as a practical matter, you're paying 40% of all the dollars over $1 million. And the question is, can you avoid that? And the answer is yes. By spending it, of course. If you could just take the $100,000, have a good time, right? But if you don't want to do that because you're married, why would you spend the money and you want to give it to your kids, etc.? Well, then there are a couple of ways to do it. We already just talked about this. I talked about that earlier. We talked about the estate tax. And we talked about this federal system, right? Which is the reason why, as a practical matter, you can always just give stuff away, right? But that $15,000 per person per child number does have one effect, if you're Mary. First of all, it has no effect if you're Mary and you've got an estate, say, of $1.3 million, and you want to reduce your reduce your estate tax, so you want to give away $100,000. So you give away, if you're at $1.3 million, your estate tax is $55,440. You give away $100,000. Now your estate is only $1.2 million. Your estate tax goes down to $49,040. You've saved $6,400, 6.4%, right, by doing that. The same would be true no matter how big Mary's estate is, if she just shrinks it down, right, to no less than around $1,120,000. But what if she's in this situation where she's at $1.1 million and she wants to get to $1 million because she wants to take advantage of the alternate tax? And using the alternate tax system, if she's at $1 million, she pays 0 in estate tax. Well, if she does that, if she tries to do it the easy way by simply taking $100,000 and giving it away, or in this case by giving away $115,000 so that she gets herself down to $985,000, it doesn't work. It doesn't work. The reason for that is if she's trying to give her way into the ability to use the alternate tax, she's got to give it away in those chunks equal to the federal exclusion, $15,000 per year. So if she just gave away to one person $115,000, while her estate would drop to $985,000, she'd still have to pay an estate tax. The estate tax would be according to the chart, and it would only be on that $985,000, but she'd still have to pay the estate tax. Okay? The alternative, if she wanted to not pay the estate tax, would be to have her tell her attorney, who has that power of attorney, look, if I get really sick and you know I'm going to die, I'm going to name 7 people. Give each of those 7 people $15,000, thereby giving away $105,000, and drop my estate to below $1 million, to $995,000. If you do it that way, even if it's the day before I die, I pay 0 in estate tax. I pay 0 in estate tax. That's the game. I know that sounds a little bit difficult to do, but the reason why I go through this is that folks in that category are really, they're just throwing away money. If you're kind of between $1 million and about $1,125,000, you're just kind of throwing away money because you're getting taxed at such a high marginal rate. It's handy if you can figure out a way to get out of that. Finally, gifts to charity simply get subtracted from your taxable estate. So if Mary had said in her will, any assets that I have over $1 million, I'm going to give to my church or the hospital or somebody, and then all the rest goes to the kids, she ends up paying 0 in estate tax. So effectively, for that last $100,000, she's given away money, $40,000 of which was going to go to the government if she didn't, right? So it's really a tremendously beneficial thing. It's a wonderful thing to make the gift, and she's really only giving away 60 cents on the dollar. The government's kind of doing a matching gift of the other 40%. We talked about that. Finally, what if Mary is not 65 years old but 80? In that case, Mary has a new concern. And that concern, and once again, assume she has the same assets for $1.1 million. She's got, first of all, actually got 2 concerns. One, the likelihood that she's going to die has increased because she's now 80. She's not 65 anymore. And so she really wants, in addition to have a healthcare proxy, to have a conversation with her proxy. She should have done this when she was younger, but she has to do it as you get to be 80 and older, about how she really wants to be treated from between then and the time that she dies if she gets sick. I always talk to clients about this. We all, as older folks, compared to our kids, we all are aware we're going to die. The kids don't believe it. They don't believe they're really going to die, right? But we know we're going to die. But it's kind of like in this distant future until it gets to the point where it's not, where because you've had a cancer diagnosis or you've had a couple of stents, your health's a little bit worse, you've got some memory problems, it becomes clearer that the amount of time that you have is more limited. At that point, you're also aware that your health during that time may be such that you really can't be making decisions for yourself. And you really want your person with your proxy to know, in that case, how you feel about how those decisions are going to be made. And I'll give you the classic case. Person has a stroke. And it's a serious stroke, and they've had strokes before. So now their capacity is really diminished. They probably can't communicate very well, and they're living at home, though, because they've got the resources, or they're in a nursing home, or they're in assisted living. But the point is, they're not in great shape. And then they get pneumonia. And so the question is, do they want to go to the hospital? Well, and if they go to the hospital, they know the hospital will cure the pneumonia. But then they're back where they were. So the question is, at that point, do you want to be back where you were? Which means, do you want to go to the hospital? Now, those are all important questions that we all face as we get older and as capacity diminishes. But the point is, if you get to make those decisions as long as your doctor says you're capable of it. But if your doctor says you're not, then somebody else is making those decisions. You want to make sure that person knows how you feel about that so they can really make the right decision. The decision not that is right for them, but the decision that is right for you. We're going to be talking some more about this, I think, in the fall. There are two major initiatives, the Conversations Project and the Honoring Choices Project, designed to do this. And I think we're going to be working on this. This may be one of my seminars, I think, in the fall. Finally, Mary is concerned about asset protection because she knows that it's possible that either she may need a lot of care at home, for which she may not have the resources, or she may need nursing home care. And in both cases, the bills are really high, somewhere between $100,000 to $200,000 a year. So in those cases, she wants to see if she can protect her assets so that, because she's probably got enough that she's not going to run out. But she'd rather leave the money to her kids and not to the nursing home or the government. So the question is, how does she do that? The reason why she's concerned about that is, first of all, she knows that if she goes to a nursing home, that cost is going to be about $14,000 per month. If her income, which you may recall, her income from Social Security is $2,000 a month, that means if she's in the nursing home, her burn rate, the rate at which her other money is going to go down, is going to be about $12,000 per month, or about $144,000 per year. Now, so Mary, unless she qualifies for Mass Health, once she is on Mass Health, her $2,000 per month will go to the nursing home, and Mass Health will pay the rest. So, first of all, you need to understand that Mary can always qualify for Mass Health. Mary can always qualify for Mass Health. So even if she didn't do any planning, she can still get qualified. Now, and so here's Mass Health 101. If she wants to qualify, her house is not a countable asset as long as she says she intends to return home. She has to have less than $2,000 in countable assets. Once she does, she'll pay her Social Security to the nursing home, and the Mass Health will pay the rest. Now, given those assets that Mary has, she could qualify for Mass Health. She can keep her house because that's not a countable asset. She can use the rest of her money to either buy an annuity, a very specific kind of annuity, an annuity that calls for equal monthly payments over a term that is shorter than her life expectancy. She can take the rest of the money and transfer it into something called a D4C pooled trust. I've talked about these before. Most people aren't aware of them. They're trusts that are administered by entities that are nonprofits that work for the benefit of elderly and disabled people. The way the pooled trust works is you transfer the money into the pooled trust. The money can be used for anything to benefit you during your lifetime. Following your death, if you've been on Mass Health will have a lien on those funds. But once the funds are transferred to the pooled trust, as far as Mass Health is concerned, they're not countable. So you can transfer all of your funds down to get you below $2,000, qualify for Mass Health the next day. There was no look-back period regarding any of this. So if Mass Health has a lien to get repaid following your death, why would you want to do that? You can qualify for Mass Health, but why would you want to do that? The answer is this. Remember that nursing home, that bed rate of $14,000 a month? So from the moment you're on Mass Health, the same bed in the same nursing home, the Mass Health rate is about $7,000 per month. The rates vary. Mass Health negotiates separate rates with each nursing home, just like the private pay rates vary, but that's a pretty typical price. So if the Mass Health rate is $7,000 per month and Mary's income is $2,000 per month, then the amount that is being paid by Mass Health to the nursing home is only $5,000 a month now, which means that lien is only growing at the rate of $5,000 a month, not $12,000 a month. If Mary, instead of putting all her money in the D4C pooled trust, if Mary buys an annuity with some of that money, and the annuity pays $5,000 per month, or $60,000 per year, and those annuity payments, as I think I mentioned to you, all of Mary's income has to go to the nursing home, Mass Health pays the rest. But if Mary buys an annuity to pay her $5,000 a month, and then her Social Security check is $2,000, which means she's now on Mass Health paying the nursing home $7,000 a month, there is no Mass Health lien. There is no Mass Health lien because Mass Health is only paying the difference between Mary's income and the nursing home at the Mass Health rate. So as a result, when Mary dies, all of her remaining assets are safe. All the remaining annuity payments that had not been paid yet to her, all the money that's in the D4C, and the house. So you need to keep that in mind, right, when you're thinking about what kind of planning you're doing. That said, if Mary wants to avoid having to spend anything on Mass Health, then her only way of doing that is to give it away. To the extent that she's got an asset that she wants to have completely safe, she needs to give it away and wait 5 years. Or she needs to get married. If she gets married, she can always transfer the assets to her spouse. But we're assuming now that Frank's dead and Mary has no interest in getting remarried. So her only way of saving the assets is to transfer the assets out of her name and wait 5 years. Now, to do that, you have to have somebody that you really trust. If you decide to do that, typically because you have a child and you trust that child, then you can just Mary could just transfer these assets to that child. She can give it away to one or more of the kids and wait 5 years. Now, the danger of that, and regarding the house, what she would do, going back to what I mentioned earlier, she'd give away this remainder interest in the house and keep a life estate in the house. That way she stays in control of the house. That way she avoids probate when she dies. And also that way, when she dies, for capital gains tax purposes, the so-called tax basis of the house jumps to the date of death value. So that when the kids go to sell the house, they can sell it capital gains tax-free. And as I mentioned to you, the plus is you avoid probate, you get this step up, and 5 years after she's done that transfer to the kids, the remainder interest is no longer countable or lienable if she needs to qualify for Mass Health. At that point, after those 5 years, if Mary applies for Mass Health and qualifies, Mass Health will put a lien on her life estate, but when she dies, the life estate evaporates, and therefore so does the lien. So the kids just get the property free and clear. The minuses of doing that is that if she was doing that transfer to avoid Mass Health, but then later on changes her mind and wants to sell the house, there'll be a capital gains tax to the extent that the people she gave that remainder interest to aren't living in the house. Because you get your exemption because you've been living in the house and owning it for at least 2 of the last 5 years. And unless she's owned that remainder interest for those 2 years, she won't get the capital gains exemption. So in this situation, what she would do is she'd ask the kids to give her back the house, and then she'd wait 2 more years if she wants to avoid the capital gains, the capital gains tax. The other problem with this is that she does have to get the kids to give her back the house if she wants it. And sometimes that's not the case because there may be one child that she really, really trusts, but maybe not all of them. That is probably the most common reason why people will do an irrevocable trust. You're doing the irrevocable trust because you're doing the exact same thing as when you're just giving it away. When you're transferring to an irrevocable trust, the trust is irrevocable. And as I mentioned earlier, that means once you've transferred the property in, you can't take it back. So it's as if you just gave it away. And Mary, in this case, would not be the beneficiary of that trust. The kids would usually be the beneficiary. And what Mary would say in that trust is the trustee, while she's alive, has the discretion to distribute any amount or some amount, she can specify, to one of themselves, to one of the kids. Now she's doing that hoping that first of all she can trust the trustee, so that if she really needs assets, the trustee will distribute some of those assets to herself or to himself and as a beneficiary, and then give them back to her, to his mother or her mother. She's trusting that that's going to happen. So this doesn't work if you don't have somebody that you can trust. But the advantage of doing this is that you can focus on the person you trust the most. If you need the assets back, you can assume that somebody's going to transfer the assets back to you. And if you do that, the issues are, can you trust the trustee? The distributions would be to the kids only. You cannot have a way to get this property back. You cannot have a way to amend this trust, nor can the trustee, to amend the trust so as to give these assets back to you, or to loan them back to you, or for any other number of reasons. Also, you cannot have a provision in there that says, in my opinion, that any of these assets can go to a nonprofit organization. I won't go through the details for that, but you shouldn't have it. We've already talked about those assets. In that situation, Mary could do all of, if Mary doesn't want to protect all of her assets, she could always decide that she wants to protect some, like the house. That's probably the most common asset that people will decide to protect. They'll say, well, I really want to keep control of my cash, but I want to protect the house. Therefore, I'm going to transfer this remainder interest out either to the kids or to an irrevocable trust and keep the life estate. So, covered a lot of material. If you've got any questions and you want it, but you know, I just talked too fast. Thank you very much to Hopkinton Cable TV for recording this and the other shows that I do here, so you can see it back on Hopkinton TV. Also, Frank and Mary have their own YouTube channel, Elder Law Frank and Mary. You can go to their YouTube channel and watch this or any programs that I do. But remember, the goal of all of this is to sleep well at night. There isn't a correct answer for everybody. The correct answer is to do the plan that helps you sleep well. Any questions? Yes, ma'am.
If you want to invoke a power of attorney,
yeah.
Verbal agreement is enough. You don't need a document.
The question is, can you revoke a power of attorney verbally? The answer is yes, right? But the question then is, kind of, who's going to believe it? If you revoke it in writing and give a copy to your bank or whatever, right? Then you say, I revoked this power of attorney on such and such a day by mailing it to or by giving it to the other person, then it's a lot easier to really establish the power of attorney was revoked. There's nothing wrong legally with just revoking it verbally, but then the problem is, how do you show you revoked it, right? Especially if there's an argument between that attorney and the new person you appointed. Any other questions? If not, thank you very much. I appreciate your coming, and I'll see you in the fall where we'll do a couple more presentations. Thank you.